All right, everybody. Welcome again to our AMA with the former USCIS officer. I am Eric Finch, a former USCIS adjudicator and a former Department of State consular officer. We're here to talk about immigration, answer basic questions, and help people understand some of the processes that they're going through that are sometimes difficult to find answers about. I want to remind everybody that I'm not an attorney. What we talk about today on this AMA is not legal advice, and I encourage everybody who's going through the immigration process to consult a legal professional, an immigration professional, if you have additional questions or need information specific to your case. All right. So with that said, let's get started. We didn't have a huge amount of questions today, so I encourage everybody who's here with us today, go ahead and submit any additional questions you have or anything that you think of while I'm talking. Otherwise, I'll move through the questions that we have, and if we wrap up early, that's okay too. All right. So first question we had, and I think this is a really important one. Will USCIS notify me if the RFE is processed correctly? So just to give a little context, after you submit your immigration application, USCIS will look at it. Their stages of their process are, quite complicated. They have an initial stage where they sort of just look over everything to make sure the application is complete. And then that is what they call the lockbox step. They'll issue a receipt number and an acceptance notice if everything is okay at that step. And then depending on what type of application you're applying for, it'll go to a number of different steps at service centers or for specialized processing. And any of the adjudicators or USCIS immigration services officers who look at your application during those various steps can issue what they call a request for evidence, meaning, with their higher level of skill and experience, they've looked at what you've submitted and they've identified some deficiency that they want you to correct so that they can continue processing your case. So, the way that most people experience this, they submit their application, wait a few months, and then they get a letter in the mail from USCIS that says, hey, we need you to submit a different copy of your birth certificate, or we need more information about your taxes for this year. And the reason for that is, they have a checklist of things that they're required to look at. And if something's missing, then that's the first thing they do is, send you a letter and ask you for it. Now, where this gets complicated is a lot of what they send on these RFEs is what we call boilerplate, like standard text says like, hey, I need this. Hey, I need this. You got to understand that these adjudicators are writing sometimes like several dozen of these a day, and they don't have a lot of time to customize it. So what you receive in your RFE sometimes is clear, sometimes simple, sometimes a little more complicated, and you need a little help understanding what they're trying to get at or what they're trying to ask for. But regardless, you assemble the things that you think are being asked for by the adjudicator, you send it back, and what happens after that? And that's really this question that we're dealing with right now. And the answer, unfortunately, is no, they don't notify you if the RFE was processed correctly. And there's the number of things that can happen after you submit your response to their RFE. If you provided the information or documents that they were hoping to get from you, then they'll just continue processing your case. You don't get any acknowledgement. It just goes to the next step. You may see some things get updated in your USCIS online case tracker, but no, they don't send anything that says like, hey, thank you. That was what we were looking for, and now we're going to proceed. When it comes to USCIS, a lot of times no news is good news. So it's, they usually don't spend a lot of time updating you or asking you for, giving you acknowledgement of the things you submitted or the things that you asked them to do. They just move on to the next step and figure that, once you get to that next step or get to your interview, basically the question will answer itself. Now, where this becomes a problem is if your response to the RFE is not sufficient or not correct, what they usually do not do is issue another RFE for the same reason. And if you're not able to provide the documents that they want, if you don't provide a satisfactory answer to their question, a lot of times they'll just move to the next step, which is to issue a notice of intent to deny. And sometimes they'll just deny outright. So if they say you need to provide this document, you respond and say, provide the wrong document or, spend too long and wait until past the time that they give you to respond. They'll usually move into a stage where they, depending on how far along you are in the process, either notify you that they're going to deny or deny the case outright. And we can get into a more complicated discussion about what denials mean and how to reapply. But generally, if you get an RFE, you submit something and then you receive a follow-up that says, hey, you didn't give us what we wanted, So we're going to give you one more chance to, fulfill this requirement before we deny you, which is what a notice of intent to deny is. Then I would very carefully read that document and do your best to respond appropriately with that, or else, you could be risking a denial. And you got to remember that, these applications can be denied at any stage in the process if the basic requirements for the application haven't been met. So that's why things like, incorrect birth certificates, incomplete tax information, if they ask for divorce certificates from prior marriages for a spousal application, you really need to do your best to satisfy that requirement as completely as you can. Otherwise, like I said, they can move straight to denial with little recourse on your part. So yes, to go back to the original question, no, they don't notify you if the RFE is accepted. Usually, if they accept what you write, they'll just move the case to the next step in processing without any further acknowledgement. And if they follow up after an RFE response that you submit with another request or a specific, another updated request, do your best to respond as quickly as possible. Now, I do want to say one other possible scenario, which is it is possible to get an RFE for one reason, respond to the RFE, have that response be fine, move to another step, and then get another RFE for something else. That's fine too. So I think what you really want to watch out for is multiple RFEs or communications, even after you tried to respond, that said, oh, this is not right, or we need something different from you. If you're getting different RFEs for different reasons over the 12, 18 months that your thing is processing, that's not as big of a deal. Just do your best to respond quickly and completely with the information that they're asking for. All right. Next up, we have is the K1 visa, K1 visa is the fiancé visa, is that visa faster to process than a spousal visa? This is a question we get a lot. I feel like we might have even talked about this in a prior AMA. But, the questions that people have frequently are questions that we need to respond to frequently. So let's talk about this again a little bit. So we do have some new information here. Just to recap, so when you file a petition for a fiancé, that's an I-129F petition. Technically, the fiancé visa is a non-immigrant visa, though it's processed much like an immigrant visa. And, that I-129F petition has a slightly different set of requirements from the I-130 spousal relationship petition that you file for a spousal visa. Now, in a perfect world, both of these things would be processed so fast that you wouldn't really need to worry about wait times. But unfortunately, the way things stand now, it is worth considering the amount of time that it'll take to get one or both of these petitions approved. And if you're applying from overseas, how long it'll take to get actually into the embassy for an appointment for these two types of visas. Now, for the K1, I think right now we're saying about 8.5 months to get that I-129F processed. That's not where USCIS wants to be. They've published some information and some timelines recently, along with an update of their average processing time readouts on their webpage that says that their goal for the I-129F K1 petition is 6 months. And I think that's an attainable goal. Prior to COVID, I think most I-129Fs were processed in around that period of time by USCIS. Now, of course, you also have to wait for the embassy step. And we know that there's large backlogs at a lot of the embassies now. So even after you get your I-129F approved and your information is sent to the Department of State, depending on where you're applying, you could be in for a several-month wait after that point. And that is new. Prior to COVID and when the backlog in situation in state was not so long, a lot of people would get that I-129F approval and then it'd be in there for their consular interview within a month or two. So, but, leaving aside, it's very hard to kind of talk in general about the consular step and the backlogs because everybody's applying from a different country. And, in a future AMA, maybe we can drill down a little bit about specific countries and what's going on there at the embassy and consulates. But for now, yes, generally speaking, the I-129F petition, even now at the current processing time, will be processed faster than an I-130. I think that has to do with a lot of things. The I-130 is a more general form. Much larger numbers of those I-130s are submitted to USCIS every year. There's different types of visas that are associated with the I-130, including parent visas, child visas, things like that. So it's just a larger pool of work. And in that sense, it takes longer, and the I-129Fs benefit a little bit from just having a lower number of overall things being submitted. And they go through a specific pipeline, whereas I-130s, I think, go to multiple different service centers depending on where you're located in the U.S. I just saw a question scroll through chat, which is related to this, so I'll answer that real quickly. The question was, does it take longer to process an I-130 if your spouse is in another country? The answer to that is probably no. The I-130, the way that they process it at USCIS is kind of agnostic. It doesn't really make a strong difference whether you say I'm going to apply at a USCIS field office for my adjustment of status, or I'm going to have my spouse apply from overseas. So no, the I-130 processing time should be pretty uniform across people who are in the same like geographic region, things like that. I don't think there's a strong difference in the amount of time it takes to process based on whether the spouse is overseas or already in the U.S. Now, for the rest of the process, yes, that can vary a lot, right? If you're in the United States already, then they're able to immediately move to the I-485 form. And depending on where you live in the U.S., you may be able to schedule a field office interview relatively quickly. Whereas overseas, again, it's going to be a product of the backlogs and things that exist at that overseas consulate. So I-130 processing time, probably not a big difference, but everything that happens after that could vary a lot depending on where you're at in the U.S. or where your spouse is at overseas. All right, got a couple questions that have come in. There was a question related to our first question, which says, is it true if you missed the response to the RFE in time, the case is not really closed and may be approved or denied based on the first evidence provided? Yeah, so in simpler terms, if you don't respond to an RFE at all, what happens? Generally speaking, they're going to deny your case because they wouldn't be reaching out for an RFE if they didn't have something specific that they needed from you that they think they need to make the case complete. Now, that changes a little when you get to the sort of like final step post-interview and they're looking at all the evidence in your file and everything. Some people elect not to respond to RFEs that are very in-depth and specific about their case because they're concerned that they might incriminate themselves or provide evidence that USCIS can use against them in immigration court. That is something that I would highly recommend you speak to a lawyer about if you're considering doing. So, for what I call administrative RFEs, where they're just trying to collect additional evidence to continue processing your case, yeah, you should always respond to those and as completely as possible, paying close attention to the instructions given by USCIS. If you're at a stage post-interview where the adjudicator is looking at your case and asking questions about whether you're overall eligible or whether, certain things that you said or did during the interview and what led up to that are going to have a bearing on their ultimate decision in your case, again, that's something where you should probably speak to a legal professional to understand exactly the right way to respond to that and what actions you should take afterwards. Okay. There was another question here. I have received confirmation from USCIS on 6 March that nothing is pending at this stage, and we are reviewing your application for your I-130 for your spouse. How long will it take? Not a lot I can do with these how long will it take questions without knowing when the case was filed and how long you've been waiting up to this point and when you received your acceptance notices. You can always look at the USCIS online case tracker, which is an online tool that USCIS provides where you can put in your receipt number and see what stage your application is in. It doesn't provide a lot of detailed information, but it will tell you, if you have an appointment or interview scheduled. I-130s at this stage, are taking about a year, 12 to 14 months. That I think USCIS has made some inroads into getting back to what has traditionally been their normal processing times for things like I-129F and I-130 petitions, but they still got a lot of work to do. Let's move on here. Let me go back to some of the pre-submitted questions. What kind of evidence should we avoid submitting for our green card application? All right, so this is kind of a tricky one. I would never encourage or insinuate that anybody should pick and choose evidence to submit for an application. My recommendation, and I've said this many times, is you need to be as honest and forthright as possible, look closely at the directions, and attempt to submit all the information that you think is applicable to your case per the instructions provided by USCIS. That being said, you need to keep in mind that these files are large and they get quite a bit larger the more evidence that you submit. And anything that you put in that file and you submit to USCIS stays in that file. So, one thing that I saw when I was at USCIS was people who would make bad decisions about the type of evidence that they would submit to support their green card or fiancé visa application. Hundreds and hundreds of pages of chat logs that they didn't look over. That, they would make a blanket request to Facebook Messenger or WhatsApp and then print that out. And then we would go through and find evidence that, they probably didn't intend to include in that application, like text messages with people that they were in other relationships with, which called into question the legitimacy of their marriage to the person that they were, applying with for their immigration benefit. Other things that people would submit, doctored photos and things like that, because they thought that would help their case. Be very cautious, because it's not just about whether, this evidence is effective in getting you the outcome that you want. If you submit things that are not correct or, are not true to your case, that can be used against you in a punitive way to deny your case, and also, cause problems for you down the line, or cause problems for your spouse in terms of ineligibility. So the worst thing you can do, and I've said this before, with these immigration cases, is misrepresent or commit fraud. You have a legitimate marriage, or you intend to get married to your fiance. You have a legitimate relationship. This is less a problem for like children and parents, but you need to be. I think it's really important to remind everybody that like what goes in stays in, and anybody can look at that at any stage in the process. I had cases where I was adjudicating naturalization, and I would encounter evidence in the original green card application that looked like they had committed fraud, or they had omitted children and people like, in their family that are required to talk about on the forms that they added later, during the naturalization step. That can all come back to haunt you. And if the agency finds discrepancies on an application, even compared to, documents that you submitted 10 or 15 years ago, that's all fair game, for them to ask about, and if necessary, apply punitive, outcomes and things like that about. So, I would especially, regarding this question, I would really stress that you go through page by page with the evidence that you're submitting and make sure that it is correct and that it reflects the relationship and evidence that you're attempting to submit. Some other areas where people have trouble is, they'll send in a giant stack of financial documents. What is that? What do those financial documents tell us? If somebody takes the time to go through those, are they going to find that what you're saying about your income and your assets is true, or are they going to find evidence that there are other things in play that may call into question whether that is really the right, financial information that you're saying it is? So, just look carefully at the evidence you're submitting. Make sure it's giving the information that you want to convey, and anything that you think that is going to distract from that outcome, or that is going to be confusing or lead to questions at your interview, you may want to consider whether that's really appropriate to include in that evidence packet. Okay, doing good on time. There was another quick question that I can answer. Will the NVC accept my Social Security income to meet the financial requirements for the public charge? In a word, yes. Social Security income is allowable for your 864 to overcome the minimum income requirement. We see that. I think at Boundless we see that quite often. At USCIS it's not quite often. There is this issue that a lot of people who are collecting Social Security, it's not enough money on its own to overcome the minimum income requirement. Because many people have relatively modest Social Security income. That's a potential thing to be careful about. It does so happen that many retired folks are able to use their assets and other things to reach that, level without too much of a problem. But, so the exception to the Social Security question is SSI. So, if you're receiving that SSI supplement, that will not count. And the other issue that people run into with the 864 form and Social Security income is, a lot of times you're not paying taxes on that, right? So the normal way that we prove income is tax transcripts. With Social Security, you're going to need to get some information from Social Security Administration and everything to prove that you have that income, because you're not going to be taxed on it. So you won't be able to use the same method that most other folks who are working use to prove their income level. But aside from that, you list it, you provide evidence that you're collecting it from SSA. It goes on your 864 form the same way that normal income would. And, if it meets the requirements, then you can overcome the financial requirement with that. All right. A couple more questions that came in over time. Question: if a U.S. resident, so a green card holder, files for citizenship, can it affect or have the non-status spouse deported? The spouse info must be provided on the application. All right, this one is a little tricky. I'm not quite sure what the questioner is getting at here. I guess if I had to sort of suss out what I think they're talking about, it would be that you have a green card and perhaps you have a spouse who is out of status for whatever reason, and then you apply for naturalization because you meet the requirement to naturalize under whatever visa that you received originally. And you're concerned by listing your spouse's information on your N-400 naturalization application, may it possibly open him or her or they up to some kind of punitive action by USCIS. They say, oh, this person is your spouse and they're living here, and now we know about them, so we're going to do something. I can't speak, to every decision that USCIS makes regarding the information that they have available. Now, I think on one hand, we should be cognizant that any information you provide to a U.S. federal government agency, and I think they say this explicitly at the bottom of these forms and in the instructions, it can be used by the U.S. government in any capacity that they feel is appropriate. There are some exceptions to that. I think when it comes to like DACA and those type of applications, the government has made some I'm not sure exactly how official, but they've made some promises that information is going to be considered like purely in the context of that application, and they're not going to look at it in other contexts for like punitive action or things like that. But yeah, we should be careful there, right? Anything we give to the government, there's a possibility that somebody could look at it and use it and talk about it, and that goes for not just immigration, but also things that you provide to USCIS, theoretically could be passed to the IRS if they want to look at tax information. There's other parts of the government, the people that administer different types of aid or support, might need to look at some of those things, and there's been talk about doing that in the past. That being said, naturalization is a huge priority for the U.S. government. It's not an attempt to suss out or find negative information about people. They want to encourage people to naturalize. And I would say the possibility that they would then dig into any, naturalization application for information, negative information about that person. Now, there's negative information that may be applicable to the adjudication of that N-400, but no, I never encountered a case, nor was there ever any instructions given to me while I was at USCIS to dig around in people's citizenship applications looking for negative information about their spouses or family members. So I guess that's the best answer that I can give, is I didn't experience that personally. Okay, got quite a few more coming in here. Let's see. My spouse, if my spouse has 2 registered addresses in different states due to being in the military, would this hurt the adjustment of status process? So, military naturalizations are kind of a complicated subject, and they have the different rules, and they are able to naturalize faster in a lot of cases. There's rules for active duty people. There's rules for guard and reserve people. Some of them are the same. Some are different. Regarding addresses in particular, I don't think it's going to have any negative impact on the adjustment of status process. There's a number of things, and that active duty service members and their family members are eligible for that are not accessible to any other type of immigrant. But rather than get into like a more complicated discussion about all the different things that apply specifically to American soldiers, I would just say that, and what I always did when I was in the military many years ago, you need to find an address that is constant, and then you need to use that for your USCIS information if possible. Now, that gets a little more complicated with adjustment of status and things, because there is, if you're going to be deployed overseas, if you are moving around due to orders, and that affects the area that you're going to apply for, going to actually perform your adjustment status interview in. So yeah, this is honestly where it gets a little complicated. And honestly, USCIS doesn't really do a very good job accounting for these type of scenarios. I have seen cases both here at Boundless and, years ago at USCIS where, a spouse of a service member was attempting to adjust status. They were trying to follow the rules around keeping up with their addresses. They arrived at the time of their interview. I recall one person in particular, had already moved to Florida, but came all the way back to Oregon to perform their interview rather than risk, missing the interview and not having it, and having their case denied. In that case, the way that the USCIS works for naturalization in particular, they'll try to then move your interview to the new location, even if you already updated your address. It gets kind of convoluted. And, I think the general rule, and I think what USCIS also says is just keep your address as up to date as possible. And if it's not an address that you think you can reliably get mail at, you need to find somebody else that's local to that area, or that you can depend on around there to collect your mail and make sure it makes its way to you. You really do not want to miss one of these interview notices. People who move around the time that the interview notice is issued often encounter problems with this. So, sorry, I don't have a better answer. Unfortunately, the address updating process is a major problem at USCIS. It's slow. It's unresponsive. They miss things. People don't get responses in a lot of cases. So I would just, as soon as you get that address updated, make sure your mail's all forwarded. Get that new address. Submit an AR-11 to USCIS as soon as possible to get the new address on their books. Do everything you can to verify that address change has been made by looking at your USCIS online account and trying to confirm it that way. And then just sort of keep your fingers crossed. Keep that old address mail forwarding in play as long as you can, and one way or another hope that interview notice makes its way to you on time. Okay. There's a couple more here. So my husband is planning on applying for a green card for me. I know he needs to prove he has enough income, but do I need to show my income as well? Questions around this I-864 form and the financial information that you have to provide on that form are probably one of the most common questions that we get, and one of the more difficult parts of the process. I'll kind of talk about a couple different scenarios here. So if we're talking about adjustment of status, then the spouse is in the United States already, and there's really kind of two different scenarios that play out here. If the spouse is already in the U.S. with a valid work permission, an H-1B visa, an L visa, something along those lines, they probably already got an individual tax number, an ITIN, or a social security number, depending on how long they've been here, and they're already paying taxes on their income. In that scenario, yes, you could file an 864. No, I might be getting it backwards. I don't want to give the wrong information, so I'm not going to say the exact method that you do this with the forms. But yeah, you can use those people who are working in the U.S. as a household member and add their income together to the petitioner, in which case you can combine those two incomes and overcome the minimum income requirement that way. That's pretty rare. Most folks who get married are not already here with some kind of work permission. Most of them are here on some kind of tourist visa, student visa, things like that, where they don't have that permission to work already, in which case, if you're in the U.S., you're adjusting status, and you don't have permission to work, then obviously that income is not going to, there's no income to count for the spouse. Now, the other one that comes up a lot is my spouse is overseas. We're applying for an immigrant visa. Of course, that person has a job in their country where they're coming from. We would like to count that income. Now, I don't think that USCIS says this explicitly anywhere, but usually, and again, to be clear, the person who's looking at your I-864 in that case is the National Visa Center, Department of State. Now, Department of State, to my knowledge, will not count foreign income. Why? So the purpose of this policy in the public charge rule is to see that when you come to the United States, you will be self-sufficient or sufficient with the resources provided by your petitioner. If you have a job overseas and you're migrating to the U.S. with a green card, what's going to happen to your job overseas? You have to quit, right? I know now remote and all these other things exist, but the way that the State Department looks at it is you have that income now, but you won't have it when you get into the U.S. Therefore, it's not going to save you from becoming a public charge issue in the U.S. Ergo, we're not going to let you count it. And there's other reasons for that, right? the U.S. the way that we work with the 864 usually involves like looking at IRS tax documents and things, which are very transparent and easy to access in the United States. When we look at all the other countries in the world, you're gonna have tax documents. We don't know what that tax regime looks like, how many people pay taxes there, what the integrity of the process is, how to translate those forms, which are probably quite complicated. So in actual fact, like usually that foreign income is just not accepted. And foreign assets are also, somewhat more worthy of consideration, but will also be quite difficult to get the agency to accept. Again, why? Well, if you say you have a house in China or India, whose name is that in? How does the law work there? How do we look at like mortgage information and see what your equity is? These are things that are just really not possible. For the State Department to do, from their stance, there at the National Visa Center, or even at the embassy level, it would be an incredible amount of work for the officers and people that staff those embassies and consulates to run down all this financial information and confirm everything. So generally speaking, what you get looked at in terms of assets and income on that 864 form during the public charge, portion of the process is going to be the salary and income of the petitioner and those assets. And again, the only exception to that would be if the spouse already has work permission in the U.S. and is collecting income and paying taxes already in the U.S. Usually that income can actually be counted. Okay, moving through these pretty good now. Let's see. There's a question: can I move to a different state for work when applying for the green card removing of conditions? So again, there's the I-751 form that you file 2 years after you receive your conditional green card. You can file it about 90 days before your 2-year anniversary. And that form is designed to, basically just check with you one more time, make sure that the marriage is legitimate, or if the marriage is already ended, that it was, a legitimate marriage until the point that it ended. I think, now they're getting to the point where they're starting to waive these interviews like much more often. I know for a while they had a policy at USCIS that they would interview anyone who received an immigrant visa overseas at this I-751 step, just to make sure that USCIS did interview. I think they've backed off that. They're applying a lot of discretion to these I-751 adjudications now, where I think generally speaking, if the case looks okay and the couple is still married, they probably won't even require an interview. So, but it kind of depends, right? If you do need an interview, then you got to apply the same logic that you apply to the adjustment of status thing here. What field office you perform these interviews at is a function of your address. Therefore, whatever address you have on file is going to be the address that they set up and expect you to appear at the field office for in the U.S. So say you file your I-751, you live in Oregon, Portland, Oregon. You'll be teed up and set up for an interview at the Oregon field office if the address on record is still in Oregon. Now, say you move to Seattle to pursue a new job opportunity there, you need to update your address so that when the agency goes to the step where they're going to schedule the interview, if they need an interview, they will be aware that you're in Seattle and they will route your case there for the interview. Now I know there's like a little bit of a trains passing in the night element here where like, I just moved a week after they sent me the interview notice, and life is like that. And in that case, it becomes a little messy because, you can still update your address, but you've already received an interview notice. And, that's one of those things where you're going to have to make a decision about whether you want to, take that, minimize your risk by just going to the interview that was originally scheduled and trying to like explain and set up the, whatever changes and things that need to be made at that time. Or, really that's kind of your only choice because, you could try to send an interview transfer request or things like that, but honestly, people haven't had really good success with that, and it takes usually longer time for USCIS to react to that notification from you than it would to just sort of show up and work with them there at the time. So again, these are decisions that you're going to have to make based on your own circumstances. It goes back to the earlier question about adjustment of status, like. You really need, especially as you get closer to your interview, to consider carefully whether it makes more sense to go ahead and complete this process successfully, or, make a change at the last minute that requires you to, update your address and make other changes that could introduce problems with your final steps to get to interview. So, I know that's not a very straight answer. It'd be nice if USCIS was much more responsive and transparent about the way they did address updates, and you could get a 24-hour turnaround, which would eliminate a lot of these problems. But that's not where they're at, and to my knowledge, they're not going to be there anytime soon. So, your mileage may vary. All right. I think we got time for maybe 1-2 more. Let's see. Wow, we're getting into some interesting DNA type questions here. So I'll take a stab at these. DNA is not a major facet of USCIS adjudication. So let's talk about it and see perhaps if it leads to some additional questions. And if people are really interested in this, I can do some research before our next AMA and talk a little bit more about it afterwards. The first question that we got was, what can be done if USCIS asks for the DNA of a baby you had with your spouse, and your spouse doesn't want to do it because he is also scared that would put them on child support? That sounds a little complicated. Like, I would imagine, if the paternity of a child is in question and there's a U.S. citizen involved, a lot of times, let's back up and talk about how children get U.S. citizenship, okay? So, if two foreigners, two people who are not U.S. citizens have a child, the child is not a U.S. citizen, right? There's no claim to citizenship. Now, if you have a scenario where there's a U.S. citizen, involved and a foreign citizen involved, then there are, in most circumstances, that U.S. citizen, again, keeping in mind, if any child is born inside the U.S., they automatically become a U.S. citizen. That's a law of the United States. Now, if the child is born abroad and one or both parents are a U.S. citizen, there's also a process by which that child can gain U.S. citizenship. They have to get what they call a consular report of birth abroad from the U.S. embassy or consulate that's closest to where they were born. It doesn't have to be the closest to where they were born, but for practical reasons, most people apply close to where the child was born. And in that case, what will happen is the U.S. State Department at the American Citizen Services section at that embassy will look at all the evidence that is involved with that birth and make a determination whether that that U.S. citizen parent, if it is a single parent, or a couple with only one U.S. citizen parent, they'll determine whether you meet the criteria to pass citizenship to the child. Which there's some of the requirements, like you have to have lived in the U.S. for a certain amount of time. There's a relationship, whether you're married, if it's a U.S. citizen father, they have to establish paternity if they're not listed on the birth certificate. So it gets quite complicated, right? For folks who aren't married and there's a one U.S. citizen involved, and I think that's kind of what they're alluding to here, there can be some question, and if there's a question about the U.S. citizen parent, blood relationship to the child, like, is it their child? Then, the way that the law is written, with the exception of same-sex couples, which have a little bit of a special regulation, the embassy, consulate is going to want to have some evidence that this child is a actual child of the U.S. citizen involved in the application. And in that case, sometimes they ask for DNA results, which is pretty much foolproof, right? Like, if you say person A, is this your child? They do the appropriate. That's exactly what DNA test is designed to do. And if it is a child of that person, then they come back with like 99.8% certainty, and then all questions about the paternity or maternity of the child are resolved. Paternity in most cases is what we're looking at, and then you can proceed with that CRIBA, get the consular report of birth abroad for the child, and they are a U.S. citizen, and instead of a U.S. birth certificate, that certificate from the consulate or embassy serves as evidence of their U.S. citizenship and allows them to apply for a passport. Now, in this case where, the question of child support is a complicated one, and it does come up with a lot of things in passport issuance, because again, you recall that I said established paternity. So for children that are born out of wedlock, if there's it is possible for, a single mother to have a child and, not just give the parents information, not have the father listed on the birth certificate, And in that case, if the mother's a U.S. citizen, then it's pretty simple for the mother to transfer citizenship to the child. Again, the U.S. government doesn't want to separate, children from their mothers in particular. Now, if there is a U.S. citizen, I've seen cases when I was adjudicating these overseas where there was a U.S. citizen, parent involved, a father who, didn't want to be in the picture and resisted requests by the consulate to, provide DNA evidence and things like that, specifically for this reason. They did not want to become, they didn't want to become dependent, they didn't want to be legally obligated to provide child support. And, this is when it gets into kind of complicated family court. Sometimes the local government there will have jurisdiction if it's a child that was born in their country, say the Philippines or South Korea. You could take each other to family court. It gets very messy. I think we all are familiar with what some of these types of cases can devolve into. But, this is another one where it's now we're talking about family court. We're talking about immigration court. We're talking about the U.S. government regulations and local government regulations. You're moving into territory where you're going to need help from a legal professional. Okay. And that person can figure out the right method to, talk about the responsibilities of the parents, what steps need to be taken according to the law to, require or obligate people to take certain tests or perform DNA tests. And that's going to vary a lot by the area that you're in. So, I know that's kind of a lot of information. But, fundamentally, if there is a U.S. citizen involved in the picture, and it's an overseas birth, there is a way to get them citizenship that way. And you should recall that basic fact, and then how that happens and what steps need to be taken, is something that you could talk to your local embassy American Citizen Services section about to get a clearer understanding of what steps you need to take. Okay. I think we're almost out of time. We'll just go ahead and wrap up, and we may have a couple questions that we pick up next time. So, with the last few minutes we have left, I just want to thank everybody for taking the time to speak to me today. I know these are difficult questions. Some of these are complicated questions. I'm happy to do what I can to answer these and provide a little bit of information and help people understand at least where they should go look for further information. Just want to reiterate, I'm not a lawyer. This is not legal advice. I enjoy having these conversations with folks. I love these questions, and I like to learn more about the Boundless community and the challenges that you're facing in the immigration process. So thank you for joining me. We'll keep doing these AMA sessions. Please keep submitting questions, and I hope this is useful, and we'll see you next time.